नमस्कार फ्रेंड्स, आज हम ऐसे टॉपिक के बारे में बात करेंगे जो डे टू डे लाइफ में आप लोग भी अपील्स फाइल करते हैं। और अपील जब हम फाइल करते हैं तो हम एक मैंडेटरी प्री डिपॉजिट करते हैं। सो व्हेन वी फाइल द अपील एज पर सेक्शन 107 सबसेक्शन 6 ऑफ द जीएसटी एक्ट, we are required to make a pre-deposit of 10% of the disputed tax so that our appeal can be admitted and it can be heard by the honorable additional commissioner or the commissioner appeals. इसमें एक बहुत बड़ा लिटिगेशन और ये कह सकते हैं कि इसमें बहुत बड़ा डिस्प्यूट ये था कि क्या ये प्री डिपॉजिट का अमाउंट इलेक्ट्रॉनिक क्रेडिट लेजर से हो सकता है या फिर इसको इलेक्ट्रॉनिक कैश लेजर से ही पे करने की आवश्यकता होती है। इस क्वेश्चन का आंसर इतना स्ट्रेट फॉरवर्ड नहीं है क्योंकि इसमें डिफरेंट हाई कोर्ट्स की डिफरेंट इंटरप्रिटेशंस हैं। ऑनरेबल गुजरात हाई कोर्ट ने इसको आंसर किया कि यस इट कैन बी यूज्ड फॉर मेकिंग प्री डिपॉजिट ऑफ 10%, बट ऑनरेबल पटना हाई कोर्ट ने इन द केस ऑफ फ्लिपकार्ट इंटरनेट सर्विसेज इसको नेगेटिव में आंसर किया और कहा कि इलेक्ट्रॉनिक क्रेडिट लेजर कैन नॉट बी यूज्ड फॉर मेकिंग पेमेंट ऑफ प्री डिपॉजिट। अब आप सोचेंगे कि इतनी कंट्रोवर्सी क्यों हो रही है, प्रोविजंस में ऐसी एम्बिग्यूटी क्या आ रही है जिसकी वजह से इतने डिफरेंट हाई कोर्ट्स के डिफरेंट ओपिनियंस हैं और मामला अल्टीमेटली ऑनरेबल सुप्रीम कोर्ट में चला गया है। तो इससे पहले हम आगे बढ़े, मैं आपको वन बाय वन प्रोविजंस को भी रीड करके बताऊंगा कि प्रोविजंस में पार्लियामेंट ने, लेजिस्लेचर्स ने क्या स्पेसिफिक वर्ड यूज किए हैं और उसका आपका क्या ओपिनियन है इसके बारे में आप कमेंट करके मुझे बता सकते हैं। तो सबसे पहले मैं सेक्शन 107 सबसेक्शन 6 का बेयर एक्ट में क्या लिखा हुआ है वो आपको बताता हूं, और आपके पास अगर बेयर एक्ट है तो आप भी इसको लें और मेरे साथ इसको पढ़ें। 1076 says no appeal shall be filed under subsection 1 unless the appellant has paid। पार्ट ए है, उसमें आपने जो एडमिट किया वो आपको पे करना है। पार्ट बी says a sum equal to 10% of the remaining amount of the tax in dispute arising from the said order in relation to which the appeal has been filed। A sum equal to 10% of the remaining amount of tax in dispute। The important word is a remaining amount of tax in dispute। I mean to say, if there is a tax liability of 100 rupees, I need to pay 10 rupees of that tax demand as a pre-deposit for getting admission of my appeal। So 1076 says this 10% is nothing, it's a 10% of the tax in dispute। The tax in dispute you have to pay before at the time of filing appeal। So 1076 is clear. It says you have to pay the tax in dispute, 10% of the tax in dispute। Now, which section is basically regulating or governing this payment of tax through cash and credit ledger? Now come to section 49 subsection 4 for a moment. Friends, 49.4 says, 49.4 in fact talks about the utilization of input tax credit for different payments। Now 49.4 says the amount available in electronic credit ledger may be used for making any payment towards output tax। The important word is any payment towards output tax under this act or under the IGST act in the such manner as may be specified subject to such conditions, etc, etc। Now 49.4 says credit ledger may be used for making any payment towards output tax। Any payment, the specific word used by the legislature says any payment towards output tax। And 1076 subclause B says amount of tax in dispute, 10% of the amount of tax in dispute। Ultimately the amount which we are making as a pre-deposit is nothing but a tax amount। It's nothing but a tax amount। Suppose you have a demand of 100 rupees and you are disputing the entire demand, and today you have made 10 rupees as a pre-deposit, and now you suppose lose the appeal and you want to pay the balance 90%। So this 10% is adjusted. This 10% is adjusted while making payment of the balance 90%। So 49.4 clearly and categorically says the credit ledger can be used for making any payment towards output tax. And in my humble opinion, and the Honorable Supreme Court has also supported the same view, that any payment includes the pre-deposit of 10%, any payment towards output tax. Now, the corresponding rule to 49.4 is Rule 86 sub Rule 2. Now come to Rule 86 sub Rule 2, electronic credit ledger. The electronic credit ledger shall be debited to the extent of discharge of any liability. The electronic credit ledger shall be debited to the extent of discharge of any liability in accordance with 49. 49 के अकॉर्डिंग कोई भी लाइबिलिटी है that will be used to discharge through electronic credit ledger. So we have discussed three provisions, friends. 1076 says payment of tax. 49.4 says any payment towards output tax. 86.2 says that it will be used for discharge of any liability in accordance with electronic credit ledger. So now the important point is the department had also issued a circular. I'm telling you which circular and what the circular says. It's a circular number 172/04/2022 dated 6th of July 2022. And if you are interested, you can go to the query number 6. And the query number 6 says whether the amount in credit ledger can be used for making payment of any tax under GST law. It categorically says any payment can be made through credit ledger which is related to the tax. So the own circular of the department clarifies this, despite that officers are disputing this, litigating this. So now what Supreme Court has held today, very clear, very categorically, Honorable Supreme Court today dismissed the SLP filed by the revenue after the judgment of Honorable Gujarat High Court in the case of the judgment says it's a Yasso Industries Limited versus Union of India, and you can note down the SLP number. It's 014841/2025, and the diary number is 17547/2025. So Honorable Supreme Court has dismissed this SLP filed by the revenue, saying that ultimately this amount, the taxpayer must be given the opportunity to use this amount for making pre-deposit of 10%. But there is a catch here. Honorable Supreme Court has also discussed in this order that the judgment of Patna High Court in the case of Flipkart Internet is still alive. With this SLP, those judgments were not disposed of. They are still alive. So we have to see now that what stand will be taken by the Honorable Supreme Court in the case of Flipkart Internet. But now, as on date, you can note down this SLP number and you can give it to your officer that the Honorable Supreme Court has dismissed this SLP filed by the revenue after the judgment of Honorable Gujarat High Court. So friends, this was a very detailed video because it is ultimately very, very critical point. We are filing many appeals, we are getting many cases when the people are not having money in their bank account. And now we are suggesting them that you can pay this 10% through electronic credit ledger because it is a good law. And now it is supported by the judgment of Honorable Supreme Court in the case of Yasso Industries versus Union of India. And it's a very latest decision. It's a today's decision. And you can refer this decision for making further appeals, etc., etc. So friends, thank you very much for watching this video. Have a nice day. Thank you very much.